Bismillahirrahmanirrahim. Chairman of the session, Honorable Minister, distinguished guests, ladies and gentlemen, Assalamu alaikum. I am Rumee counsel at BIAC, and I have the honor to walk you through the event today. We at BIAC thank you for your continued support as we celebrate 10 years of our existence. On this occasion, we have arranged today's seminar on dispute resolution in the virtual world, the impact of COVID-19, and we are delighted to have our well-wishers with us. Bangladesh International Arbitration Centre began its journey back in April 2011 as the first institution for alternative dispute resolution in the country, under a license from the government of Bangladesh. Our founding chairman is Mr. Mahbubur Rahman, and our sponsor institutions are the International Chamber of Commerce Bangladesh, the World Business Organization, Metropolitan Chamber of Commerce and Industry Dhaka, and the Dhaka Chamber of Commerce and Industry. We will begin today's celebration with recitation from the Holy Quran by Maulana Muhammad Kamrul Islam.
السلام عليكم ورحمة الله وبركاته. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. يا أيها الذين آمنوا قوامين لله شهداء بالقسط ولا يجرمنكم شنآن قوم على ألا تعدلوا اعدلوا هو أقرب للتقوى واتقوا الله إن الله خبير بما تعملون صدق الله العظيم. হে মুমিনগণ, তোমরা আল্লাহ তাআলার উদ্দেশ্যে ন্যায় সাক্ষ্যদানের ব্যাপারে অবিচল থাকিবে এবং কোন সম্প্রদায়ের শত্রুতার কারণে কখনো ন্যায় বিচার পরিত্যাগ করিবে না। সুবিচার করো, এটাই খোদাভীতির অধিক নিকটবর্তী। আল্লাহ তাআলাকে ভয় করো, তোমরা যা করো নিশ্চয়ই আল্লাহ তাআলা সে বিষয়ে অবগত আছেন। আল কুরআন, সূরা আল মাইদা। আসসালামু আলাইকুম ওয়া রাহমাতুল্লাহি ওয়া বারাকাতুহু.
Distinguished guests, the English rendering of this verse is as follows. Bismillahirrahmanirrahim. In the name of Allah, the most gracious, the most merciful. O you who believe, stand out firmly for Allah as witnesses to fair dealings, and let not the hatred of others to you make you swerve to wrong and depart from justice. Be just, that is next to piety. Fear Allah. Indeed, Allah is well acquainted with all that you do. Now we have a brief presentation on the screen on BIAC's activities and achievements over the years. Ladies and gentlemen, I now invite our Chief Executive Officer to deliver the address of welcome. As you know, Mr. Muhammad Rumee Ali joined BIAC as CEO in October 2015. He is a veteran banker and was Deputy Governor of Bangladesh Bank. He is the founding chairman of bKash, the first mobile financial service in Bangladesh, and CEO of Standard Chartered Bank Bangladesh. He has been associated with various institutions, including non-banking financial institutions, NGOs, telecommunication, and so on. He is currently chairman of the board of AB Bank Limited. Over to you, sir.
Chairman of today's session, Mr. Mahbubur Rahman, Chairman BIAC, our chief guest, Honorable Minister for Law, Justice and Parliamentary Affairs, Mr. Anisul Huq, MP, the speakers and distinguished guests, ladies and gentlemen, Assalamu alaikum. Welcome to the 10th anniversary seminar of BIAC, and thank you all for coming to share this important event this morning with us. For me, the 10th anniversary is a special one because this will perhaps be the last time I'll be addressing you as the CEO in an anniversary celebration. Today, I will not speak on why the country needs ADR, as I have done in my first appearance in this role in 6th, and continue to impress on you its importance every year, this year, and finally offering you a reprieve. I will instead take you through my personal journey at BIAC. In one sentence, the last 6 years has been a challenging and intensely learning experience like no other. I say that because the day I started work at BIAC reminded me of my first day at work at Bangladesh Bank as a management trainee in 1975. I know I'm on a nostalgia trip, and I seek your indulgence. At my age, when I'm supposed to be brimming with wisdom, knowledge, and confidence, here I was thinking, what now? Of course, the reason was obvious. My knowledge of arbitration, mediation, and ADR was limited to my lone visit to BIAC, where I went as a visitor many years back. And I remember nodding my head, pretending to take it all in to impress them. This wasn't banking in a commercial bank or the central bank, nor was it trying to make sense why a not-for-profit NGO must get involved in business. I stepped into an area that has been traditionally the domain of the legal fraternity. And sure enough, I got my first warning from a very well-known barrister friend who will of course, go unnamed. He pulled me aside after my name was announced as the next CEO at the 5th anniversary event by our chairman, Mr. Mahbubur Rahman, and in a hushed voice told me, Rumee, are you sure you know what you have taken up? I guess I've decided to find out the hard way, was my limp reply. Best of luck, was his chilling response. And talking of our chairman, I must say, one of my first discoveries was his immense power of persuasion. My earnest entreaties to him that he has chosen the wrong person did not deter him at all. He kept insisting for more than a month, and to make sure he enlisted the support of Shamim Bhai, Mr. Latifur Rahman, and Fazlu Bhai, Mr. Fazlur Rahman, and finally my wife Tamara. And after the assault by this formidable force made me quickly come to the conclusion that capitulation was my best option. And having made my proverbial bed, I had no choice but to make the best of it. And the last 6 years has been just that, trying to make the best of it. After I joined Team BIAC, I needed to know the individuals, and we together needed to plan our future, a sustainable future, And to do that, we spent a day at a retreat and came up with our mission, vision, and action plan. And what was so special about it? For BIAC, it was the first participatory strat plan. And we set our milestones for our journey. And here are some of the highlights of our past 6 years. In 2016, we completed the first mediation between a Japanese investor and his Bangladeshi counterpart in just 14 hours. We also completed the very first international arbitration under BIAC rules, which was invoked by Rahman Chambers. The first ever seat of arbitration proceedings of an international arbitration with well-known international arbitrators was held at BIAC also in 2016. The arbitrators also participated in a well-attended seminar which was chaired by the governor of Bangladesh Bank, held at DCCI. Another important success the same year was Bangladesh Bank recognized BIAC officially with a letter to all banks conveying their endorsement of BIAC. In 2017, we signed the debt resolution project with World Bank IFC. Same year, we were recognized for our contribution to ADR by Rahman Chambers with an award. In 2018, Bangladesh Bank convened a committee led by BIAC CEO comprising of members from the Banking Regulations and Policy Department of Bangladesh Bank, BIAC and Association of Bankers Bangladesh to draft guidelines for ADR for banks in Bangladesh. This was completed and submitted to Bangladesh Bank. BIAC also gained the recognition as a training institution from the Judicial Administration Training Institute and participated in training assistant judges attending the 38th Foundation training. We also held a similar module at BIAC at the invitation of Ministry of Law for senior assistant secretaries. And in 2020, we held the first inter-university mock arbitration contest. In 22 international cooperation agreements have been signed so far with institutions like International Court of Arbitration at The Hague. Our international partners now include many national and multinational institutions. We held 145 outreach events, 13 arbitration and 22 hearings, 18 virtual hearings, and in this context, let me say that BIAC was the first institution in this geography to start virtual hearings. 44 mediation with 14 meetings. Our training program has been very successful. Till the pandemic struck, our figures are 72 courses on arbitration, mediation, and similar topics with around 2,000 trainees. Our member facilities offers a platform for all practitioners and those interested in ADR to congregate and share ideas and knowledge. And I'm delighted to announce that we are hosting the first inter-university international arbitration contest in 2021 in December this year with the participation of universities from India, Sri Lanka, and Pakistan. A very sad event that I must recall was the loss of our inspiring leader, whose help and personal commitment was instrumental in setting up BIAC, Mr. Mahbubur Rahman, a man who stood out as a beacon of ethical business and as a founder member of BIAC. He will be missed. I believe success is a journey and not a destination. And what we need for the journey is first a well-equipped ship. I think we do have the infrastructure and capacity, but there is one vital ingredient that is missing in BIAC, and that is adequate fuel. In the words of the layman, we need funding. The pandemic decimated our income streams to zero. If adequate funding is not made available, it is just a matter of time. BIAC, a national institution that has successfully established itself both nationally and internationally, will unfortunately have to close its doors. Ladies and gentlemen, with sustained effort by BIAC team, we achieved self-sufficiency in 2019, generating a small surplus. but the pandemic hit us and we have just about survived the body blow. But frankly, we have not found the way out and become sustainable. I'd like to take this opportunity of the presence of our Honorable Chief Guest to appeal to him to save this national institution. The Honorable Minister has always been very helpful and has been a friend of BIAC, and I'm sure he'll guide us to find the way. I believe every country needs a national institution, ADR institution. BIAC fits the bill in every way. And it will be sad to see BIAC become history. For me, personally, this will be devastating. I'd like to extend my grateful thanks to the sponsor of today's program, AB Bank, Petrochem Group, Lenden, BD and Capco, and Paramount Insurance. I would also like to thank the institutions who have contributed towards the publication of the souvenir. My very special thanks to our Honorable Chief Guest, Minister for Law and Parliamentary Affairs, Mr. Anisul Huq, MP, our speakers, our distinguished guests, members of our board, and finally our chairman, Mr. Mahbubur Rahman. As a departing CEO, I would be remiss if I did not very specially thank my team. And I start with my senior colleague, Director Ahmad Azad, our formidable General Manager, Mahbuba, our finance manager, who made sure that every taka was spent right, Ashikur Rahman, our legal brain, Counsel Rubaiya Ehsan, our fix-it-all man, Syed Shahid, and of course, Shahida Parveen, who keeps BIAC in the news and on the web up to date. I must not forget Asif, who joined us recently. I also recall two of my colleagues who were with us and their contribution, Afreen Ahmed and Fahmida Islam. And of course, last one, but not the least, Zakir and Luqman, who make sure everything at the office is working. Without their individual and collective effort as a team, we could not have succeeded as we did in 2019 or survived the pandemic. Thank you all very, very much for me personally. Ladies and gentlemen, I will now say goodbye, but sign off with see you next time. I hope I have the pleasure and the privilege of attending the 11th next year with you as a guest. Thank you.
Thank you, sir. Our friends from a number of overseas institutions have kindly sent in congratulatory messages to celebrate BIAC's 10th founding anniversary. Unfortunately, they could not join us in person. We take this opportunity to express our gratitude to Ms. Apita Kuminder, Head of Uncitral Regional Center for Asia and the Pacific, Mr. Wang Shengjie, Vice Chairman and the Secretary General of the China International Economic and Trade Arbitration Commission, Mr. Paul Sanlosham, Chairman of the Chartered Institute of Arbitrators, Singapore. In fact, they've also kindly sent in a beautiful gift to us as a gesture to celebrate this anniversary. And last but not least, Dr. Pasit Asawa Watanaporn, Managing Director of the Thailand Arbitration Centre. A very special thanks goes out to Ms. Nina Mucheva, Senior Financial Sector Specialist of the International Finance Corporation of the World Bank Group. Ms. Mucheva has closely worked with BIAC since its initial days and has always supported BIAC. Let's have a look at their video messages on screen.
On behalf of the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, or UNCITRAL ARCAP, congratulations to the Bangladesh International Arbitration Centre, or BIAC, on its 10th anniversary. UNCITRAL is an intergovernmental body established by the General Assembly in 1966 as the core legal body of the United Nations system.
We're experiencing a slight technical glitch, but we should be back online shortly. Please bear with us.
Recognizing that disparities in national laws impeded the flow of trade, UNCITRAL was mandated to promote the progressive harmonization and modernization of international trade law by preparing legislative standards in various areas, including commercial arbitration and mediation. The regional center was launched in Incheon, Republic of Korea in 2012 to further the UNCITRAL mandate in approximately 60 jurisdictions in the Asia Pacific, including Bangladesh. We are delighted Bangladesh has adopted a number of UNCITRAL texts, including the New York Convention, the Model Law on International Commercial Arbitration, and the Model Law on Electronic Commerce. We would encourage Bangladesh to further consider adopting texts recently prepared, taking into account developments in the field and evolving user needs, such as the Singapore Convention on Mediation. Enthusiasm for the work of UNCITRAL amongst stakeholders in Bangladesh continues to grow, evidenced by the well-attended first joint UNCITRAL RCAP BIAC webinar held in April 2021, illustrating how UNCITRAL dispute settlement instruments strengthen a legally enabling environment in Bangladesh and the region for business and cross-border trade. We look forward to enhancing our collaboration with BIAC and Bangladesh, and thus encourage stakeholders in Bangladesh to reach out to us with initiatives at uncitral.rcap@un.org. Congratulations once again on BIAC's 10th anniversary, and thank you for giving the Regional Center the honor of delivering this message.
Good morning and good afternoon, everyone, depending on your time zone. My name is Nina Mucheva, and I'm a Senior Debt Resolution Specialist with the World Bank Group's Finance Competitiveness and Innovation Global Practice. I wish to extend my heartfelt congratulations on the 10th anniversary to the leadership, staff, clients, and supporters of the Bangladesh International Arbitration Centre, the first of its kind alternative dispute resolution institution in the country. Over the last 10 years, BIAC not only managed to establish itself as the lead provider of ADR services in Bangladesh to banks and businesses of all sectors, but also managed to make itself known well outside the boundaries of the country and to position Bangladesh as an ADR-friendly jurisdiction in the Asia region. We at the World Bank Group are proud that we supported BIAC's establishment at the very initial stages and commend BIAC's efforts to create an enabling environment for the banking and private sectors in Bangladesh to resolve their disputes out of court in a faster and efficient manner. With its expansion of ADR services to cater for financial disputes, we believe that BIAC will contribute to the efforts to create a more sustainable financial sector in Bangladesh, leading to an increased access to finance for domestic businesses, particularly small and medium enterprises. Under the leadership of BIAC's chairman, Mr. Mahbubur Rahman, and its chief executive officer, Mr. Rumee, we expect to observe even greater achievements in the next few years through continuous collaboration with key Bangladesh industries and the financial sector. And I'm very sorry that I cannot be with you in person, but I wish everyone a successful workshop.
尊敬的阿里主席，各位来宾、各位朋友，大家好，我是中国国际经济贸易注册委员会副主任兼秘书长王胜杰。至此，孟加拉国际仲裁中心成立10周年之际，我谨代表中国国际经济贸易仲裁委员会，向会机构表示热烈祝贺。孟加拉国际仲裁中心是孟加拉的首家国际仲裁机构，一直致力于为当事人提供中立、高效、可靠的经济解决服务。中国有一句老话叫做“10年磨一剑”。10年来，会机构所取得的成绩，彰显出你们为推动仲裁作为解决国际商事争端的重要手段所做出的努力。近年来，贸仲与孟加拉国际仲裁中心建立了友好合作关系，我们之间不仅签署了合作协议，孟加拉国际仲裁中心还作为创始成员加入了由贸仲倡议设立的“一带一路” 国际仲裁机构改进良好宣扬合作机制。未来，双方将继续通过信息交流、人员互访等方式加强合作，使两机构在服务国际经贸活动中发挥更大的作用。在此，我再次衷心的祝贺孟加拉国际仲裁中心成立10周年。我们期待两机构之间友谊长存，合作永续，在国际仲裁未来的发展中携手并进。
Ladies and gentlemen, I'm Paul Sandosham, the Chair of the Singapore branch of the Chartered Institute of Arbitrators. On behalf of the Singapore branch, I would like to convey my best wishes and congratulations to the BIAC as they celebrate their 10th founding anniversary on 30th October this year. The Singapore branch of BIAC have had a long and close relationship, going as far back as 2017, when we co-organized a course on international arbitration in Singapore. Since then, we have organized various arbitration courses together. I would like to take this opportunity to wish the BIAC much success in the coming decade and look forward to continuing our close relationship with the BIAC. Thank you.
Honorable Anisul Huq, Minister of Law, Justice and Parliamentary Affairs. Ladies and gentlemen, greetings from Thailand. It is with immense pleasure that Thailand Arbitration Centre joins the celebration for the 10th foundation anniversary of our friend, the Bangladesh International Arbitration Centre, or BIAC, the leading arbitral institution in Bangladesh. Since 2016, when we signed a memorandum of understanding, our centers have been working closely to promote the use of alternative dispute resolution as the preferred method for settling disputes, and Asia as a world-leading place for dispute resolutions. We have been supporting and organizing successful events on arbitration and mediation for the past 5 years, and we will keep working and supporting each other in the years to come. It is an honor and a pleasure to have such an important organization as a companion on our journey for the success of ADR. Due to the pandemic, it would be impossible for us to join in-person celebration for the BIAC anniversary, but we wish to visit you in Bangladesh as soon as it will be possible. On behalf of Thailand Arbitration Centre, I wish all the best and the brightest future to the BIAC. You can always rely on the support of our center. Thank you.
Ladies and gentlemen, I now request our respected chairman, Mr. Mahbubur Rahman, to take over as the chairman of today's session.
Thank you, Rashman. According to our program, now that we have with us our speakers of today's event, and in the list of the speakers, I have Rashma Imam, barrister at law. He is an advocate of the Supreme Court of Bangladesh. He is the managing partner of Akhtar Imam and Associates. Our areas of interest in legal practices including corporate and commercial, foreign investment, labor and employment, banking, commercial arbitration, power insurance, and anti-corruption and bribery laws, among others. She completed her Bachelor of Masters of Law, Bachelor and Masters of Law from the University of Buckingham, UK, and Bachelor of Civil Law from the University of Oxford. May I now request Ms. Rashma Imam to present her presentation. I would like to say that definitely We have, from our secretariat, they have spoken to each of the speakers and would definitely request each of them for kindly remaining within the time frame in order to finish it well in time. Thank you so very much. That's my remark.
Thank you very much, sir. Honourable Minister, Ministry of Law, Justice and Parliamentary Affairs, Mr. Anisul Huq, Honourable Justices of the Supreme Court of Bangladesh, Honourable Chairman of BIAC, Mr. Mahbubur Rahman, respected senior advocates of the Supreme Court of Bangladesh, the Chief Executive Officer of BIAC, Mr. Rumee, ladies and gentlemen, a very good morning to you all. I'd like to start by congratulating BIAC on its 10th founding anniversary, the very reason why we're here today. As a member of the bar, I'm grateful to BIAC for the instrumental role that it has played till date in raising awareness single-handedly almost about the benefits of alternative dispute resolution in Bangladesh, and of course for holding training sessions and training programs, which is very much needed, and for facilitating the settlement of commercial disputes out of court. In the long run, I believe this is bound to lessen the burden of the courts in Bangladesh and, of course, create an enabling business environment in Bangladesh, which is speedy dispute resolution translates into a thriving business environment. Moving on to the topic before us today, which is the impact of COVID-19 so far as dispute resolution is concerned in Bangladesh. Apart from the obvious health and economic impact of COVID-19, access to justice took a hit when the courts of Bangladesh closed down in March 2020. We, the members of the bar, raised our voices on various public platforms and social media platforms about the dire need for the virtual operation of the judiciary. A mechanism had to be carved out in which the judiciary could continue to operate despite the ravaging COVID-19 pandemic. The third organ of the state, the guardians of the Constitution, we felt cannot remain static in such a situation and during a crisis of this scale and duration. So these were clearly extraordinary circumstances and extraordinary measures were called for. The Supreme Judiciary of Bangladesh, the Ministry of Law, Justice and Parliamentary Affairs, with the help of our development partner UNDP and a technical team of E2I, through a concerted effort, rose to the occasion and made history by launching virtual courts for the very first time in Bangladesh. So this moment truly marks the official introduction of dispute resolution through virtual means, so far as Bangladesh is concerned. So on the 9th of May, the Honourable President promulgated an ordinance that paved the way for the virtual operation of the judiciary. The challenges with virtual courts were and still are not insignificant by any stretch of the imagination. From internet connectivity to technical glitches to lack of training to lack of resources at all levels. Virtual courts literally meant a steep learning curve for judges, for lawyers, and for court officials. Some perhaps felt, rather many from the bar felt that the biggest challenge or the biggest flaw in this system was the fact that lawyers, all lawyers did not have access to laptops, smartphones, or desktops for that matter. So lack of resources of the bar was also an additional problem that was highlighted. And perhaps this is the reason why virtual courts have been looked upon as a stopgap measure, a temporary solution to this problem to control the spread of the COVID-19 virus, yet continue with a judicial function. And it has been till now looked upon as something that will be discarded the moment the pandemic recedes. I personally feel that that is probably where the problem lies. The pandemic is unlikely to go away anytime soon. It is unlikely to disappear overnight, or it's impossible to say when it will subside or recede. And of course, in any case of the matter, the prospects of virtual courts, and we have had a glimpse of those prospects, is something that we cannot ignore. The potential virtual courts, or for that matter, virtual dispute resolution, even if it's arbitration or mediation, the potential it has in efficiently dispensing justice in the long run cannot be ignored. So virtual hearings mean reduced costs for clients, no travel or waiting time in court, which all members of the bar have suffered and continue to suffer, and overall much less impact on our commercial clients. And besides, of course, the obvious benefits virtual hearings have on commercial clients, for commercial clients, it is much more convenient for frail or sick litigants, for litigants who have to travel a long distance to attend a hearing and who probably cannot even afford the travel cost, and of course in sensitive cases. Also, since, as I said earlier, the pandemic is unlikely to recede anytime soon, retaining virtual courts, even if it is on a limited scale, is the only way we can continue to benefit from the wisdom and experience of our senior lawyers. We have lost far too many senior lawyers to the COVID pandemic in the last 1.5 years. And of course, moving on from virtual courts to virtual alternative dispute resolution as an arbitration or mediation, these share similar challenges and similar prospects. I might even argue that the challenges are less daunting so far as virtual ADR is concerned. So far as our Arbitration Act is concerned, there is no dearth of power under the Arbitration Act 2001 to hold virtual hearings. Section 25, Section 26, they give enough freedom to the parties to decide on a procedure, to decide on a place of arbitration. And of course, there's no legal bar to fixing a virtual platform such as Zoom or, for that matter, Skype or Teams as the place of arbitration. The arbitration rules and procedures of international arbitration institutions like the International Court of Justice, ICSID and SIAC permit the use of video conferencing and virtual hearings in one form or another. However, in Bangladesh, in this context, there are practical difficulties. Most, again, it starts with training. Most arbitrators, most counsels are not familiar with the concept of conducting or taking part in a full-fledged virtual hearing on a digital platform. And of course, there is a significant difference between video conferencing and actually conducting a virtual hearing. Virtual arbitration hearings would, among others, ideally require a digital database of all pleadings, documents, and laws filed, and are referred to by the parties, and an operator controlling the video link, a separate operator ensuring easy and efficient access to particular documents, so on and so forth. Therefore, extensive training is called for so far as virtual ADR is concerned, and of course the technology has to continuously adapt and improve and evolve as we go on, but this again can only happen if this practice of virtual hearings is retained, even if on a limited scale. Leading arbitration centers around the globe, they're partnering with service providers like Epic, like Opus to improve the experience of virtual hearings. For example, I've learned that in Canada, Arbitration Place now offers Arbitration Place virtual, and Australian dispute centers offer Australian dispute centers virtual. So these arbitration centers are coming up with virtual platforms. And these specialized institutions that the arbitration centers are partnering with, they are providing custom-made software and hardware for virtual hearing capabilities. Perhaps the arbitration centers in Bangladesh, and a leading one like BIAC, may also consider, if they have not already done so, in partnering up with organizations that can provide the technological or other state-of-the-art technologies. With that, as and when the pandemic recedes, I strongly believe that we should retain virtual courts, virtual arbitration, and virtual mediation, even if it is on a limited scale. The pandemic has made us realize how technology is much more cost-effective and much less time-consuming so far as dispute resolution is concerned. And I sincerely hope that the profession does not regress to pre-COVID times, and having had a glimpse of the prospects of virtual hearings, instead we should all join hands to address the challenges that stay in the way of virtual resolution of disputes in order to efficiently integrate this into the system of justice delivery in Bangladesh. Thank you very much for your patience. Assalamu alaikum.
Walaikum assalam. Thank you very, very much indeed. And you are all the practicing lawyers in the country, and we always depend on you and look forward towards your support in spreading the alternative dispute resolution outside the court. Thank you so very much. May I now invite Professor Dr. Farhana Hilal Mahtab. Farhana Hilal Mahtab is the Associate Dean, Department of Law, Faculty and Humanities and Social Sciences at the Daffodil International University. She has been teaching for more than 2 decades. She completed her Bachelor of Laws, Master of Laws and PhD from the University of Dhaka, among others. She participated in various training programs, workshops, conferences at home and abroad, including training of trainers in arbitration, organized jointly by BIAC and International Law Institute of Washington. Dr. Farhana, the floor is yours.
Assalamu alaikum. Honorable Chief Guest, Mr. Anisul Huq MP, Honorable Minister, Ministry of Law, Justice and Parliamentary Affairs, Government of the People's Republic of Bangladesh, the Session Chair, Mr. Mahbubur Rahman, Chairman of BIAC, Mr. Muhammad A. Rumee Ali, Chief Executive Officer BIAC, and the distinguished guest. All praise due to Almighty Allah that we all are here at the 10th founding anniversary of BIAC. In the World Justice Project's Rule of Law Index 2021, Bangladesh ranks 124th out of 139 countries globally and 4th out of 6 countries regionally. Specifically, Bangladesh ranks 5th out of 6 in South Asia in both civil and criminal justice dispensation. While the ranking improved by 1 step from 2020, the figures are of grave concern. It shows how the justice dispensation worsened during the pandemic. Our government took an unprecedented step by enacting the Adalat Kortik Totthyo Projukti Byabohar Ain 2020 to inaugurate virtual court proceedings for the first time in our history. The Supreme Court also issued practice directions for both divisions and all subordinate courts of Bangladesh from time to time to accelerate the dispensation of justice. While only urgent application and bail matters were being heard initially, one practice direction ordered all subordinate civil criminal courts and tribunals to hear and dispose of all types of civil and criminal appeals, revisions, as well as hear arguments and deliver verdicts in civil suits virtually. But practical implementation of this direction was daunting for the courts due to the lack of specific procedures to regulate online hearing, especially regarding using technology and taking evidence in virtual proceedings. Regrettably, our Parliament has still not enacted the Law Commission's draft Shakho o Bichar Karjokramer Totthyo Projukti Byabohar Ain 2019, which could have solved this problem. Meanwhile, India has already passed rules on live streaming and recording of court proceedings to accelerate virtual courts and online judicial dispute resolution. Despite having a draft law earlier, we failed to capitalize on it and take our judicial system forward. Looking on the brighter side, our virtual court system has been a success despite functioning in a limited capacity. Throughout the 2 lockdowns and during the operation of virtual courts 2020 and 2021, the Bangladesh judiciary disposed of more than 2,15,000 bail petitions, more than 1,06,000 detainees were released from prisons following the virtual hearing of their bail petitions. The Appellate Division disposed of 10,000 cases during this period. Moreover, Several High Court division benches disposed of more than 500 cases every working day through virtual hearing. But this is the tiny home. The limited operation of virtual courts during the pandemic may worsen the state of the backlog of cases. Presently, over 38 lakh cases are pending in both tiers of our judiciary. Experts fear that the case backlog may rise from 38 lakh and even cross 50 lakh if situation doesn't improve. To tackle this problem, only judicial resolution disputes will not be sufficient. This is where we need to focus more on ADR mechanism in Bangladesh. The Supreme Court has provided 2 remarkable circulars on increasing mediation initiatives to resolve disputes. On 21st March 2021, the Supreme Court Circular 3J directed to all subordinate courts to mandatorily use ADR to resolve suits under the relevant provision of CPC 1898, the Arbitration Act 2001, the Money Laundering Court Act 2003, and Labour Act 2006. On 5th August 2021, the Supreme Court Circular 4J provided detailed guidelines on the procedure to undertake mediation mandated under the above-mentioned laws. These guidelines aim to help subordinate courts to conduct effective mediation to resolve disputes. This is a forward-looking and proactive approach by our Supreme Court, as it is at crossroads to tackle that impending backlog of cases, a case of headache that the COVID-19 pandemic has aggravated. However, similar to virtual courts, we need to focus on online dispute resolution (ODR) in the field of ADR in new normal situation. While we have a specific law relating to virtual courts, it is high time now to enact similar legislation on ADR virtually. We will not be out of place to mention that factors such as access to internet, digital literacy, due process, and cyber security and privacy should be given utmost importance while devising the law procedure for ODR. The High Court Division also flagged these as significant challenges to overcome to make our virtual court system a success while rejecting a writ petition which challenged the constitutionality of the Adalat Kortik Totthyo Projukti Byabhar Ain 2020. BIAC has been a pioneer in the field of institutional arbitration in Bangladesh. During the pandemic, they have continued to resolve disputes by taking recourse to online tools in arbitration procedures. A praiseworthy initiative of BIAC was organizing the first ever inter-university arbitration competition among the top law schools in Bangladesh last year. The event's success proved that online dispute resolution could ease the burden of the case backlog if appropriately implemented in Bangladesh. Being a law professor, I must say it added another feather to the 10 years successful journey of BIAC. Lastly, through the Honorable Minister of Law, Justice and Parliamentary Affairs present today, I earnestly request the government to take the necessary steps in this regard. Thank you all.
Thank you, Ms. Farhana. Thank you so very much for your presentation. And so we can consider that our private universities are also now taking the initiative of taking this ADR and introducing the course on various such law-related issues in the private universities, which is a very good sign, and we look forward to exchange our ideas and thoughts with the educational institution, particularly the university, who are teaching law in their respective faculty. May I now request Ms. Humaira Azam. Mrs. Humaira Azam is the Managing Director and Chief Executive Officer, Trust Bank Limited. If I am not mistaken, She is possibly the first lady chief executive of a commercial bank in Bangladesh, which is that demonstrates the women empowerment of that Mr. Rumee Azam is the managing director and CEO of the Trust Bank Limited, with over 3 decades of experience in banking industry. She is the first ever Bangladeshi woman to be specialized as one of 300 influential women in Islamic business and finance in the world by UK-based financial intelligence house Cambridge IFA in their Women take intelligence. Okay. Men I Report 2020. She started out as a management training in ANZ Real Bank and moved on to work with the HSBC, Standard Chartered, IPDC of Bangladesh, and Bank Asia. Humana, the floor is yours.
Bismillahirrahmanirrahim. Assalamu alaikum and good afternoon to everyone. Honorable Minister, Mr. Anisul Huq, Minister of Law, Justice and Parliamentary Affairs, Honorable Chairman BIAC, Mr. Mahbubur Rahman, and CEO BIAC, Mr. Rumee, and all the honorable guests. I think I will also talk in a little bit informally because we are in the banking industry and I think we are the biggest sufferers as far as litigation, arbitration and justice is concerned because I think major number of dispute arises from the financial sector of this country and as there are many banks now, I think especially after the pandemic, we all, whoever is present from bank would understand the humongous amount of legal cases and disputes right now we have in our hands. Because what has happened that there are willful defaulters and there are also unwillful defaulters. When it comes to willful defaulters, the number somehow has increased quite a bit because I think we have had a history where we were carrying a lot of unresolved cases and some people also took this opportunity of pandemic and decided that they will also pursue possibly some of their previous cases and people who have not like willful defaulters. So I think in my also span of career, I have to deal with a lot of cases and what I have found that basically you have cases unresolved for 20 years, 25 years, but I was able to, it's a question of how much preference people will put when they are going to come and use an informal platform. So I have found that people do prefer an informal platform rather than a formal platform, or for the obvious reasons. The moment the formality thing comes in, it's a psychological aspect and people would like to possibly avoid it. So things got resolved. So this is my practical experience and it was like thousands of crores of takas in my journey which were resolved outside the court and after many years. So this is one thing that we see that the convention was very much there and the beginning was very much there through the New York Convention for Arbitration. So what has happened, people have taken that on, many countries are involved in it, but the usage was very limited. And for our country, I think it started out with BIAC. So, and what we can see that so far, especially with the pandemic, it has been used very successfully. So with the number of cases and everything that is there in the market, I think going forward, there is, if we really think about it, there is no alternative. Unfortunately, we see that Authorin Adalat came in being, and in 2003 it enacted the law that was related to also arbitration. But that arbitration is after all the things have happened, because in post case you have gone through all the bitterness, including even the auctions. So when you are sitting with the parties, aggrieved parties, they are already bitter and they have exhausted their financial sources and they do not feel good at that point in time to settle something. So I think arbitration should be adopted much earlier. And also I think this is something I think our Honorable Law Minister can look at, because once it is done, I think up to certain amount, like up to at least $2 million or $3 million, if the cases are outside the code, because the numbers are also stick to possibly a formal number of 3.7 million cases, and we talk about the days it takes to resolve it, because we see the processes and we can see that you have to go to the courts 20 or even 25, 26 times or even more to resolve a case. So which is unbearable. And when will you get the time? When will you get the dates? It's a very lengthy process, and we have seen many people die even in the process to get a result at the end of the day. So how we want to go about it is also a question, and as I said that we should incorporate an arbitration at the very beginning, so that before going to the court up to certain level, this should be taken on by the mediators. And what is good about mediation, we have set up an institution for that, and the people who are sitting there are very well qualified to handle this, and so they are also capable of corresponding across the borders. And the moment the informality comes in, it's the better side of it, because you don't have to know all the loopholes of legal side of it also. And when you are looking at the legal systems as well, different country has got different legal systems. And so it's a question of the thorough knowledge and understanding, and two sides legal counsel sitting together and working it out and all that. So I think it's very important, as I said, to take in at the beginning of it. And I don't want to say it in such a manner, but what I can see that Authorin Adalat Ain has not been able to support us much, because the amount of, now if we really look at it, we have seen even 9.3 to 10% bad debt in the banking industry. So that goes to tell you that things are growing, and we haven't been unable to contain it or settle it through the channels those are there in the legal system. So I think it's at this point in time, parallelly, we have to go with an informal institution, and I think BIAC is very much capable. And although we have adopted New York Convention and all the modern litigation processes that is there outside the court, and which is through mediation, but I still believe that we can look at Singapore Convention. They are very near to us, and they have also done a very good work during the pandemic. So I think it's only a question of adopting, and at the end of the day, practicing and establishing. Since we have the license and we can do the necessary, I think it's important that we take it on. So one other thing, I think what I can recommend also, that the adversarial litigation could be remedy of last resort, and the court could impose the exemplary fine to the parties who avoid ADR before coming to court. Because then, as the numbers have grown, to make it manageable, I think if this is doled out, this is going to work well also. And at the end of the day, again, if I look at the workability of Authorin Adalat, once we even get a result, also the parties have the capability to go to the court and bring in an injunction and a stay order and things like that. So it is not the way to handle the situation that is now prevailing in the banking industry, because it is one of the worst that we can see, and also we still feel that the amount that is really there after pandemic, also the deferrals and everything, how things are going to work out going forward if we do not have an immediate measure and if we do not actually quantify what is there in all the banking books and what should be dealt with where, and that needs to be decided. And I think there needs to be a small body which should find it out with a joint collaboration of the banks, of the even ADR and the court, and then it should be decided that the major amount which are small in nature, like $2 or $3 million, as I mentioned earlier, should go for the alternative dispute resolution and dealt with in the mediation. I think I have said enough, but I think at the end of the day, we are the biggest sufferers from this situation, and I think because majority of the disputes that arises are commercial in nature, so this is something I think we have to look at very carefully, and I think it's a brilliant thing that we have now BIAC in Bangladesh, and it is celebrating the 10 years. I would like to congratulate BIAC, and I wish them all the success, and I think the question of also survival of BIAC will depend on all the banks and they allowing their parties to be able to handle the situation informally through BIAC, which will also give the lifeline of earning for BIAC as well. Thank you very much. Assalamualaikum.
Thank you very much, Mrs. Azam, for your very practical situation, presenting very practical situation that is now prevailing in the banking industry. And as you have said, the accumulation of such cases in the court, even if it is regularly heard, it won't end up in anybody's lifetime. So therefore, it has to be alternative dispute resolution methods has to be adopted by Bangladesh as early as possible, and in practice must be encouraged from now on, or because it is already too late. At this point of time, I would like to invite Mr. Tariq Afzal, President and Managing Director of AB Bank. Mr. Tariq Afzal is the President and Managing Director of AB Bank. He was CEO of Shonali Polaris Financial Technology Limited, a joint venture of the Shonali Bank and Polaris of India. Mr. Afzal worked in the Credit Union of Canada, ANZ Village and Standard Chartered in Bangladesh. He also worked in Bank Alpala, Bragg Bank, and served as the CEO of Dun and Bradstreet Rating Agency in Bangladesh. He has an MBA in Finance and Marketing from Victoria University, Melbourne, and BBA in Marketing from Middlesex University in UK. Mr. Tariq Afzal, the floor is yours.
Thank you, the session chairman. Thank you for presenting my credentials. As you see, I must confess, I failed my father to be a legal practitioner, and here I am as a banker. Forgive my audacity. All the councillors at law. Honorable Chief Guest, Mr. Anisul Huq MP, the Honorable Minister for Law, Justice and Parliamentary Affairs of the Government of Bangladesh, Mr. Mahbubur Rahman, Chairman, Bangladesh International Arbitration Centre, Mr. Rumee Ali, CEO of BIAC, former Deputy Governor of Bangladesh Bank, judges from the Apex Court, and councillors at law. Assalamu alaikum. It gives me immense pleasure to congratulate BIAC on successfully completing 10 years of functioning as possibly the sole ADR institution in Bangladesh, As you all know, this is a very special year, 50 years of independence and the centenary celebration of our father of the nation. And we celebrate 10 years of BIAC as well. Congratulations again. Going back to the topic, ladies and gentlemen, in the words of the learned justice, Her Lordship Sandra Day O'Connor, the first woman judge sworn in 1981 in the United States, the courts of this country should not be the places where resolution of dispute begins. They should be the places where the disputes end, after alternative methods of resolving disputes have been considered and tried. In the past 18 months, the pandemic has changed the global perspective on what is access to justice. During the pandemic, need for quick, efficient and virtual solutions showed how new techniques and the availability of online communication platforms are urgently needed, locally and globally. As you have heard from the learned speaker, in May 2020, the Honorable President of Bangladesh promulgated an ordinance that paves the way for virtual operation of the judiciary. However, I feel we are still in the early stages of adapting to this new system. Therefore, it is imperative for all to explore alternative methods of dispute resolution, especially for us in case of commercial disputes, as you heard from the learned speaker, Rumee. Since its inception, BIAC has been striving to improve the dispute resolution processes of Bangladesh. The backlog of cases pending in the courts has long been a matter of concern for all lawmakers. In this regard, I believe BIAC has a substantial role to play in this important field of beyond usual adjudication process. As a member of the banking sector, I feel it is pertinent to find innovative ways of countering issues dealing with default loans. Even though Arbitration Act 2001 of Bangladesh has given us a guiding law for invoking arbitration and process, however, under the virtual dispute settlement, there still remains the issue of ability of parties and the arbitrators to conduct virtual arbitration sessions, and also the unavailability of digital infrastructure at times. However, despite such shortcomings, arbitration under the Act took place to resolve many, including commercial disputes in Bangladesh. As you heard from our learned speaker, High Court disputed over 700 cases. But that too was on priority. Many hearings were not heard, bail petitions were not heard, and dispute on money loan suits perhaps fell behind. Ladies and gentlemen, I am pleased to inform you, AB Bank signed an MOU with BIAC in 2019 with the view of recognizing the effectiveness of ADR in contractual disputes. We will continue to participate in training and discussion on arbitration and mediation method with BIAC. Also, we will continue to promote the process of out-of-court settlement, both virtually and in appearance, to establish an alternative to the conventional judicial system of Bangladesh. I wish BIAC all success. Thank you for your patience, and thank you once again for giving me this opportunity to be here today. I'm honored. Thank you.
Thank you very much, Mr. Tariq Afzal. You have been involved in the process as a banker for some time, and we look forward for your support, and particularly on the banking industry, who are also suffering huge because of the lot of defaults in their cases. And as I said earlier, that if you are depending on the court, and more important than money loan court, that you are not going to have this resolution of money any time from now. Thank you so much indeed. And may I now invite Mr. Justice A.F.M. Mahbubur Rahman, former judge, High Court Division of the Supreme Court of Bangladesh, a barrister at law from Lincoln's Inn, London, Justice Rahman is an international arbitrator and member of the London Court of International Arbitration, Chartered Institute of Arbitrators, UK, and Bangladesh International Arbitration Centre. His field of practice includes civil, banking, and admiralty laws, company matters, writ petitions, and arbitration. He authored many books on law and history. He studied law in the University of Dhaka and University of London. Justice Rahman, the floor is yours.
Thank you, Mr. Chair. Bismillahirrahmanirrahim. I am here today with a very joyful heart, only to hail today's celebration of 10th anniversary of BIAC. After 2 years of stagnance of all the meet and greet program, anywhere in any manner within or outside Bangladesh, due to, as you all know, the stupid, infamous COVID-19 pandemic. Honorable Chief Guest of this celebration, the Honorable Minister for Law, Justice and Parliamentary Affairs, Mr. Anisul Huq MP, the Honorable Chairman of BIAC, Mr. Mahbubur Rahman, Mr. Muhammad A. Rumee Ali, the Chief Executive Officer of BIAC, the distinguished guest speakers, Mr. A. F. Hassan Arif, Mr. Tariq Afzal, Ms. Humaira Azam, Professor Dr. Farhana Hilal Mahta, Barrister Rasna Imam, sitting in the podium, and the distinguished audience sitting in front of me. Assalamu alaikum, and a very good morning. At the very outset, I would like to mention that I am a stakeholder of arbitration. I am an arbitrator, previously a judge of the Supreme Court of Bangladesh, now acting as an international arbitrator. And at the very outset, I like to mention that the advancement of technology, especially the information and communication technology known as information superhighway, has taken us to such height that we could beat the pandemic COVID-19 to some extent in a way which allowed us to continue with our dispute resolution process, either through court proceeding or through the method of alternative dispute resolution, ADR, through a very innovative method known as virtual hearing system. And the person behind the introduction of such mechanism in our court proceeding in Bangladesh is sitting with us, the Honorable Minister for Law, Justice and Parliamentary Affairs, Mr. Anisul Huq MP. It is he who acted quickly on the issue as the key man behind the advancement of virtual system of hearing of the court proceeding during the COVID-19 pandemic. Had there been no introduction of the virtual hearing system in our High Court Division and the Appellate Division, there would have been no disposal of cases during these 2 years of stagnance, and consequently a pile of cases would added with already existing huge backlogs of files in the Supreme Court and also in the subordinate judiciary. Thanks to our Honourable Minister for his timely introduction of this beneficial system in our judiciary. But so far, the area is concerned, the virtual hearing system of arbitration or mediation has not been flowering at part the court proceeding. The reason behind, among others, is the non-change of mindset of some of the stakeholders to adapt to this new system, and that appears to be the great hurdle to advance the idea through virtual mechanism or even through physical hearing, despite the fact that the incumbent government is well aware of the situation and taken positive steps towards popularization of the ADR mechanism by amending a number of the existing statutes, especially the Code of Civil Procedure, by introducing Section 89A and 89B, which allowed the litigating party to attempt for mediation of their dispute out of court, keeping the court proceeding alive to take further step in the matter. But alas, that being the optional provision, the learned counsel of the parties did not appreciate the mediation provision for the reason best known to them, and consequently the litigating parties remained deprived of this beneficial amendment made by the Parliament. So I reckon that this optional provision must be made mandatory, it must be imperative to compel the parties to take the benefit of this ADR system. The government of the day has been sincere to adopt changes, and again, some of the civil, fiscal, and family litigation are made amenable to ADR through amendment of relevant statutes such as Income Tax Ordinance 1984, Customs Act 1969, Orthodox Adalat Ain 2003, Value Added Tax Act 2012, EPZ Trade Union and Industrial Relations Act 2019, Family Courts Act 1985, Muslim Family Law Ordinance 1961, Real Estate Development and Control Act 2010, Village Court Act 2006, and many more. But the benefit to be achieved from these amendments remains zero. All these amendments also pave the prospective development of ADR landscape in the dispute management system. Nevertheless, despite these amendments and the sincere efforts of the incumbent government, the ADR landscape has not been developed in Bangladesh up to the mark. The reason behind is the absence of adequate trained ADR personnel to assist the disputing parties to use the ADR mechanism. The other reason is the non-cooperation of the governmental agency and bureaucracy rigidity to use this alternative channel, which they feel to be prejudicial to their claim against their citizens. Now I will turn to the theme of the day, dispute resolution in the virtual world, the impact of COVID-19. As you all know, the global crisis due to the pandemic has impacted immensely on the international business world, especially in dispute resolution in the commercial matter. The BIAC has aptly reacted to such crises and in inventing new norms for handling of dispute resolution by quickly converting cases originally fixed to be resolved in person to virtual resolution, being cost-effective and efficient system that allows dispute in between the international parties to be arbitrated, mediated, and negotiated through information and communication technology, properly known as virtual system. This has allowed an aggrieved party from Singapore to take the advantage of a celebrated arbitrator staying in UK to resolve his dispute with a party from China. Recently, I personally disposed of an arbitration on admiralty matter. The learned counsel for the claimant of which appeared from UK, and the counsel of the other party was in Singapore, and myself as sole arbitrator had been in Dhaka at my residential chamber. 3 or 4 of the virtual sitting was required to resolve the whole dispute, which was earlier pending in the admiralty bench of the High Court Division of the Bangladesh Supreme Court during my tenure in that bench till 2018. That's the charisma of the virtual hearing mechanism of ADR. But there is the challenges in popularization of virtual method of ADR at this initial stage of usage. Some of the learned advocates say that this is the system for the rich lawyers who have absolute facilities to use at their own grip. Some say that the very slow speed of the internet in Bangladesh is another great hurdle against smooth progress of the proceeding from commencement to end. But whatever be the dissatisfaction of the learned counsels against the system, the initial stage of virtual mechanism may have some flaw on smooth proceeding of ADR. Nevertheless, the same will be washed out through continuous use of the mechanism. Unless we use this system continuously, we may not be acquainted with its flaws to wash it out, and once we will be habituated with this system, the entire dispute resolution world will be benefited at the time of crisis, not only the present COVID-19, but against any future prospective pandemic. I suppose that government should retain the virtual hearing system in our court system and also in the world of the ADR. I'm grateful to BIAC, its Honorable Chairman and the CEO for allowing me an opportunity to deliver a few words in favor of ADR through virtual mechanism, and also to the distinguished audience for rendering a patient hearing. Allah Hafiz. Thank you all.
Thank you very, very much, Justice Abdul Rahman, all speaking from his practical experience and what he has seen and what he has been practicing in this case. I would say thank you, Justice, again for your support to BIAC and we look forward all members of the legal fraternity will come out to support this out-of-court settlement of the commercial dispute. Otherwise, it won't gain ground in Bangladesh. And it is absolutely essential, despite the fact that we all know there are many millions of cases that is pending for years, for decades, and also we have shortage of judges and everything. I must also congratulate our Minister for Law and Justice that he has been addressing this, and also to appoint new judges in the court in order to settle the outstanding disputes and cases. But that's not enough, because it is also impossible to resolve all these accumulated cases overnight. There has to be, but alternative dispute resolution has to be in practice in full swing. Justice Rahman, thank you very much once again. And at this point of time, may I invite Mr. A.F. Hassan Arif, the former advisor to the caretaker government of Bangladesh and former Attorney General of Bangladesh. Mr. Hassan Arif is a senior advocate of the Supreme Court of Bangladesh. He was an advisor to the caretaker government, and he also served as the Attorney General of Bangladesh. Mr. Arif is specialized in practicing alternative dispute resolution, administrative law, VAT, customs, income tax, excise and labor law matters. He was a member of the National Dialogues for Parliamentary Election 2008. Mr. Arif is a panel arbitrator of BIAC. Mr. Arif, the floor is yours.
Bismillahirrahmanirrahim. A very pleasant good morning to everybody. The Honorable Chief Guest, Mr. Anisul Huq, MP, Honorable Minister of Law, Justice and Parliamentary Affairs, Government of the People's Republic of Bangladesh, then the Chair, Bangladesh International Arbitration Centre, Mr. Mahbubur Rahman, and Mr. Rumee, the distinguished Executive and CEO of BIAC, who has taken BIAC from a position in 1915 till today, and BIAC is what we see today is because of his single-handed effort with the team behind him. Only day before yesterday, 2 days back, I, as one of the arbitrators, along with the chairman of the tribunal, Mr. Justice Mahbubur Rahman, Mahbubur Rahman, and another co-arbitrator, Mr. QC from Singapore. Thank you. As well as say, concluded an arbitration 2 days back, which was conducted virtually. So this credit goes to BIAC. BIAC provided us all the facilities. The chairman of the tribunal used the arbitration, the premises of BIAC, and Mr. Fazlul Hussain from Singapore, and I from my own chamber. So the ADR, I would suggest, and submit, that has adopted the virtual hearing very well. And this virtual proceeding, though it was not so popular or not, it was not coined as such, 4 or 5 years back, there was an arbitration in BIAC, in its old premises, where the tribunal was constituted by 3 Chief Justices. His Lordship Justice Latifur Rahman, His Lordship Justice Chaudhary, and His Lordship Justice Tafazul Islam. And the claimant was from UK, London, and the respondent was obviously from Bangladesh, and the witnesses in the proceeding were from USA. So we used, I'm not sure whether it was Zoom or other means of technology through which we conducted the hearing. So the virtual hearing is not absolutely a new phenomenon so far as arbitration is concerned or conferences is concerned, but arbitration, when it goes to BIAC, that it did organize such arbitration proceeding. Because if those who have visited the arbitration center or BIAC, the present one as well as the old premises, you would have noticed that each room had all the technological facilities in place so that we could have used the benefit of technology in conducting international arbitration, visualizing, taking into consideration that if it is international, then obviously the participants, the stakeholders would be from different countries. So, to begin with, that virtual arbitration has taken its place in Bangladesh as well. It is significant that while we are celebrating the 10th anniversary, this is coinciding with 100 years birth anniversary of Mahbubur Rahman Sheikh Mahbubur Rahman and the 50th anniversary of Bangladesh. And also the centenary of ICC, International Chamber of Commerce, that is also celebrating its 100th year. And I quote from a passage of the ICC literature. It says like this: pandemic forced us into confinement. However, arbitration work had to continue, and thus we discovered working remotely. Through this ingenious use of technology, we realized that all of our constant traveling and face-to-face meeting were in fact not so essential. From our office and at the height of the pandemic from our own home, we have come to discover that we are more efficient in this new virtual world. Indeed, the world of arbitration flourishes without the need for the so-called arbitration tourism that made us waste our lives at airport, hotels, and exhausting meeting rooms. And whilst we were increasing the efficiency of our work, we were questioning the very way in which we had been carrying our arbitration proceedings, questioning the basis of international arbitration. We were rethinking the paradigm of international arbitration. So we may say that this passage from ICC literature has set the tone for virtual hearing of ADR matters, be it negotiations, be it conciliation, be it mediation, or be it arbitration at the end of the day. At the impact of COVID-19 pandemic massively disrupting the global economy, there is increasing contractual dispute and potentially greater demand for emergency relief. But delaying the proceedings of an arbitration, mediation or resolution of dispute frustrates the whole spirit of ADR. And the COVID-19 pandemic poses the challenges for such delay. In order to mitigate the adverse effects of the COVID-19 pandemic in dispute resolution, we had to adopt full-fledged virtual proceedings, including conducting conferences and hearings by audio conference, video conference, or other similar means of communication. And being used to the software for such communication. Thus, dispute resolution in the virtual world is now a reality. It is of course true, and that's a reality as well, that many of our speakers have spoken earlier about the drawbacks, about the pitfalls that we face in popularizing virtual ADR hearing or in the judicial proceeding as well. A debate is now going on about continuity of virtual hearing of judicial processes. During these 1.5 years and more, many of us, particularly elderly senior lawyers, we have been conducting our hearing from our chamber or home, particularly before the appellate division. It is to be pointed out that the productivity of the appellate division through virtual hearing is more than when it is physical.
Yes, definitely.
So it should be taken into consideration whether it should be outrightly got rid of or it should continue. And many factors are there which the ICC passage says the time consumed in physically presenting himself or herself before the court. So these are factors which the Honourable Minister may kindly take into consideration before taking the views of that portion of the lawyers and the legal community, legal fraternity, to completely do away with the virtual hearing of judicial process. We may improve if there are pitfalls, if there are difficulties, technological or any other. Definitely we may overcome that by talking to each other, trying to find out the problems and trying to resolve it instead of avoiding it. And also I may point out the point raised by Madam Humaira Hazam about the ADR in Orthodox Adalat cases to overcome the backlog of cases as well as the huge amount of bad loans stuck in Orthodox Adalat. The Honourable Law Minister may consider whether the present provision of ADR in the midst of the judicial process or proceeding before the Orthodox Adalat is suitable or a mandatory pre-ADR, that means before initiating this litigation or before initiating the cases, there should be an attempt of ADR may be considered, and maybe the bankers, lawyers' opinion and consultation be taken into consideration. And I would suggest BIAC to organize such a discussion between bankers and lawyers and judges as well. Dialogue. Because it's my view that if there is a mandatory ADR before you initiate the proceeding, then the borrower will be very much eager to come to a settlement instead of dragging, because he has then the prospect that if it goes to the court, then the stringent consequences of Orthodox Adalat will be upon his head. So the Democrat's sword is on his head. He will be more willing to come to a settlement than he would if it is in the midst of the trial. And Madam Azam has rightly pointed out that by that time the factual aspect has to be taken into consideration as well. The respondent, the borrower, by that time also is exhausted financially and from point of view of engaging lawyers, etc. So that's a view which I believe worth consideration. Then coming back to the virtual world, in order to cope with the impact of COVID for fair and efficient resolution of disputes, the parties, councils, tribunals, and administrative staffs have shared obligation to consider procedural measures that can mitigate the disruption in the arbitral process. Virtual case management, working remotely, can be an effective way to overcome the critical situation by increasing the efficiency of the arbitral procedure, requesting documents be filed in electronic form, communicating virtually with all concerned, conducting virtual hearings and deliberations of awards virtually, etc. In this case, I will point out that ICC has taken this very seriously, and as far back as April 2020, they have issued a guideline for arbitral tribunals, participants, and lawyers and counsels in this. The ICC guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. And they have suggested that in order to minimize the time for resolution of disputes virtually, the tribunal may also minimize or emphasize the most important aspect of the dispute. Instead of taking all the 5 disputes or 7 disputes together, the dispute which is clinching factor, that means which will decide all other issues, could be taken up. And also minimize the evidences, whether it should be appropriate to decide the dispute relying on documents instead of going for evidentiary materials bringing before the tribunal. So they have suggested many ways for minimizing the time frame consumed in arbitral proceeding while conducting it virtually. So the COVID-19 pandemic and its impact on all sectors, including in dispute resolutions, compelled to consider the way ahead to minimize the disruption in dispute resolution by ensuring that disputes could continue to be resolved on a fair, expeditious, and cost-effective basis through virtual means, facilitating business and commerce move forward. And in fact, we may recall that the disruption of supply chain started as far back as December 2019, when it was first noticed in China. So all the imports from China coming into Bangladesh, mostly raw materials, particularly in the garment sector, were disrupted. That resulted in differences and dispute between the Chinese importer and Chinese exporter and Bangladeshi importer. And that again, as a chain, impacted our export of garment to the buyer. So there was a chain of breach in the supply chain, consequently leading to breach in the contract. And COVID-19 once again became a factor for consideration by during the arbitration. Whether it could be considered as a force majeure for suspending this performance of the contract. So the arbitration that we have concluded only 2 days back, the COVID-19 was also an issue. That whether it will act as a force majeure in order to delay the performance of the contract or not. So virtual hearing, the COVID-19 has not only impacted the physical hearing, it has ushered in a new technology of hearing the arbitration proceedings, not only arbitration, all other ADR mechanisms, but it has also led to increase in the number of disputes and differences. So COVID-19 impact is not only in the world of commerce and economy, it has its impact as well in the resolution of those disputes which arise because of the COVID-19. And so I submit that BIAC is doing a good job by facilitating virtual hearing of ADR. So I thank once again BIAC for asking me to say a few words. Thank you very much.
Thank you very much, Mr. Hassan Arif, who has been a supporter and cooperator as far as the alternative dispute resolution is concerned. And one thing that you also know, the World Arbitral Institution, the leader in the World Arbitral Institution, the ITC, International Chamber of Commerce Arbitration, which is called the International Court of Arbitration, which is being led by the International Chamber of Commerce, and they are in the private sector. They are the number one leading arbitral institution, and Mr. Hassan Ali is also one of their governors in that case. And thank you very much, Mr. Ali, for all your support, and we look forward that you will all join us in promoting alternative dispute resolution in Bangladesh outside the court as much as possible, and the Honorable Chief Guest has been supporting this initiative, and he will continue to do that, and more importantly now that virtual arbitration procedure should be more strengthened so that it may even continue even after the pandemic. Thank you very, very much, all our distinguished speakers. And at this point of time, I must say that we are more or less within our time frame, and may I now call upon our Honorable Chief Guest, His Excellency Mr. Anisul Huq MP, Honorable Minister, Ministry of Law, Justice and Parliamentary Affairs, Government of the People's Republic of Bangladesh, and our big supporter in promoting arbitration in Bangladesh. Mr. Anisul Huq MP, as you all know, he did no introduction, but nevertheless, just for your recollection, the Honorable Minister is since January 2014. He had his honors and masters in English literature and Bachelor of Laws from the University of Dhaka. He had his Master of Laws from the King's College, University of London. And Mr. Huq practiced as senior advocate in the Supreme Court of Bangladesh. He was Chief Special Prosecutor for both the Bangabandhu murder case and the jail killing case. Mr. Huq was also the Chief Counsel and the Special Prosecutor for the Anti-Corruption Commission, Bangladesh. Mr. Anisul Huq, the floor is yours.
Thank you, Chair. Thank you. Bismillah ar-Rahman ar-Rahim. Honorable Chair of BIAC's 10th Founding Anniversary Seminar, Mr. Mahbubur Rahman, Chairman of BIAC, respected speakers, Mr. A.F. Hassan Arif, former advisor to the caretaker government and former Attorney General of Bangladesh, Mr. Justice A.F.M. Abdul Rahman, former Judge, High Court Division, Supreme Court of Bangladesh, Mr. Tariq Afzal, Managing Director, AB Bank Limited, Mrs. Humaira Azam, Managing Director, Trust Bank Limited, Professor Dr. Farhana Hilal Mehtab, Daffodil University, International University, and Barrister Rashna Imam Advocate, Supreme Court of Bangladesh. CEO of BIAC, Mr. Muhammad A. Rumee Ali, distinguished guests, ladies and gentlemen, Assalamu alaikum, and a very good afternoon. I feel honored to be here with you all at this seminar, Dispute Resolution in the Virtual World, the Impact of COVID-19. commemorating the 10th founding anniversary celebration of the Bangladesh International Arbitration Centre, BIAC, which has already achieved remarkable progress in facilitating arbitration and mediation in respect to commercial and business disputes between the adversaries. Ladies and gentlemen, businesses have a preference for quick and straightforward approach to settlement of disputes which may not be possible within the vicinity of the courts. Moreover, there is no privacy or assured deadline in the proceedings of civil courts. Therefore, businesses and legal experts across the world have started changing the dispute resolution scenario and brought about alternative dispute resolution methods. Out-of-court settlements of commercial disputes, such as mediation and arbitration, facilitates quick and effective resolution of disputes. ADR as a method of dispute resolution has been in place for Bangladesh for quite a long time, though on a limited scale. The Arbitration Act 2001 brought Bangladesh on the threshold of modern arbitration. For businessmen and entrepreneurs who are competing in this globalized world, it is imperative that they incorporate global best practices and seek to put into practice these methods and processes. I congratulate BIAC for adopting the theme Dispute Resolution in the Virtual World, the Impact of COVID-19, for its 10th anniversary seminar. In today's perspective, this theme is most relevant and very timely. I'm confident that the outcome of the seminar, which BIAC will definitely take forward, will help create the right atmosphere and charter a new pathway for more ADR-friendly legal infrastructure in the new normal Bangladesh and carry progress onward. In view of the ongoing extraordinary circumstances created due to COVID-19, the government has enacted the use of Information Technology by the Court Act 2020 to carry out trials through digital means. Our judiciary has already started conducting proceedings via video conferencing. I urge upon businesses to join hands with BIAC so that we can promote the concept and practice of ADR facilities among our manufacturers and exporters, who will definitely help maintain the economic sustainability of all the vital sectors of the businesses in Bangladesh. It will also help us to learn and deal with COVID-like situations more pragmatically in the future. Therefore, even if COVID-19 goes away, hopefully, the virtual courts are here to stay and its jurisdiction will be extended. To meet the challenges of the present reality and the modern world, we are transforming the capabilities of our judiciary by introducing e-judiciary provisions at a cost of Dhaka 2,270 crore. The present government, under the competent leadership of the Honorable Prime Minister Sheikh Hasina, appreciates very much the growing need and significance of ADR. In keeping with such realization, we have amended many laws to incorporate ADR for arbitration and mediation and resolve disputes. There was also a mention of a proposed law, Shakho Vichar Karyakram Totthya Projukti Byabhar Ain 2019, and a question posed as to why it is not being enacted as law. I would like to inform all present here that as we have embarked on the task of overhauling and modernizing the Evidence Act 1872, we will incorporate provisions dealing with admissibility and procedure provided for in the proposed law in the said Act. Therefore, the necessity of that Act will not be there. Thank you. The government of Prime Minister Sheikh Hasina has taken steps to ensure that both foreign and local arbitration awards can be enforced in Bangladesh, and we are encouraging all government entities to choose Bangladesh as the first instance as the place of arbitration for contracts. I feel encouraged to see that BIAC has already become renowned for its arbitration facilities. From the very outset, BIAC has been working hard to create awareness about ADR facilities by conducting several outreach programs, seminars, webinars, workshops, trainings, and dialogues. I appreciate all such initiatives of BIAC to promote practice of settlement of disputes through ADR methods. Business leaders and organizations now recognize the significance of BIAC as an institution which not only provides with suitable infrastructure for arbitration, but also imparts training on ADR to mediators, arbitrators, judges, legal professionals, bankers, government officials, and students in Bangladesh. One of the key highlights of BIAC is the BIAC Arbitration Rules 2019, which provides an opportunity to parties to opt in a set of international arbitration rules, which has been compiled by local and international arbitration experts with the assistance of renowned global arbitration institutions. Recognizing the recent initiatives and efforts by BIAC towards resolution of commercial disputes outside the court, the government of Prime Minister Sheikh Hasina is considering to incorporate appropriate clauses for arbitration and mediation in all government contracts. And the Legislative and Parliamentary Division of Prime Ministry will initiate a proposal soon in this regard. Honourable participants, I congratulate Mr. Mahbubur Rahman, Chairman BIAC and President in the International Chamber of Commerce Bangladesh, for his pivotal role in establishing BIAC and relentless efforts in raising the stature of the country's only ADR institution to an international level since its inception a decade ago. I have high hopes reposed in BIAC and its commitment to promote adherence to the cost-effective ADR landscape in the country and beyond, which will definitely help dispose pending bulk of civil cases throughout Bangladesh. Ladies and gentlemen, I believe as BIAC grows, so will grow the confidence of the domestic and foreign entrepreneurs in Bangladesh's ability to handle complex commercial disputes and attract them to invest here. I wish BIAC every success in its journey and for all the endeavors. I am confident that BIAC will continue to play an emphatic role in ensuring access to justice in commercial disputes and boost its diversified programs in the years to come. I also take this opportunity to assure BIAC that the government of Sheikh Hasina will always stand by and cooperate with BIAC in the days ahead. Already, I am processing an application for a grant of Dhaka 10 crore from the government of Bangladesh with the Finance Ministry, and have been assured that the same will be finalized and dispersed shortly. Thank you all. Joy Bangla, Joy Bangla.
I have no words. I'm short of appropriate words to say thank you, Honourable Minister, for your very encouraging and supporting assurances for making alternative dispute resolution a more institutional one and more practicing people and members of the legal fraternity to use the alternative dispute resolution methodology outside the court. And more importantly, as our Chief Executive has mentioned, because on the initial day we had been supported by the World Bank IFC for some time, and for the last several years we are on our own. But in view of the fact that the ADR did not take its roots as it should have been, unfortunately the revenue income outside our budgetary provisions is not as it should have been, and more importantly, independent. All our revenue earning projects are almost being to a standstill. From that point of view, we are having or suffering for quite some time. And Honourable Minister, he is the witness to all our initiative, and he has been supportive to us unconditionally for various, and he has been also working in the government in order to create an enabling environment for ADR to take root in the practicing field. And I would like to say, Honourable Minister, thank you once again for your kind support. And thank you, sir. So, as such, I'm very unhappy in a very lighter words with the Honourable Minister, because every time he joins us, he leaves us before lunch or before dinner. And today also he has announced that he should be released before lunch.
It is unconditional.
He has some other things to attend, but nevertheless, he has never ever said that any invitation from the BIAC that he said that I may not be able to come, but he has been always there. And not only that the financial assistance that he has been trying to make it, and now that he has also announced that he is on his way to make it, but that's not the only consideration. The support from the Ministry of Law and the necessary amendments to the Acts are very, very important and vital for BIAC to stay. And for that matter, I would like to say, Honourable Minister, thank you once again. Thank you so very much. We are grateful to you.
Ladies and gentlemen, considering that our Honourable Chief Guest has very little time at the moment, we would like to shift the memento session before the closing remarks. May I request our Chairman to present the 10th anniversary memento to our Honourable Chief Guest, His Excellency Mr. Anisul Huq, Minister for Law, Justice and Parliamentary Affairs.
Sir,
I now request our Chairman to present the 10th anniversary mementos to our distinguished speakers. Kindly step forward as I call out your names. Firstly, we have Mr. A.F. Hassan Arif, former advisor to the caretaker government and former Attorney General of Bangladesh.
Sir, ওইখানে থাকলেও হবে
অনেক সময় লাগবে to save you time.
Mr. Justice A.M. Mahbubur Rahman, former Judge, High Court Division, Supreme Court of Bangladesh. Mr. Tariq Afzal, President and Managing Director, AD Bank Limited. Ms. Humaira Azam, Managing Director and Chief Executive Officer, Trust Bank Limited. Professor Dr. Fahana Hilal Mehtab, Associate Dean, Faculty of Humanities and Social Science, Daffodil International University. Barrister Rashna Imam, Advocate Supreme Court of Bangladesh, and Managing Partner Akhtar Imam and Associates. Ladies and gentlemen, to commemorate 10 years of BIAC, the team would like to thank our chairman for always inspiring us to work hard and leading us through this decade-long journey. Because of his motivation and personal commitment to BIAC, despite his busy schedule, he has always looked out for us and continued to put in the effort to make this institution a sustainable one, even during the current crisis period of the global pandemic. We are honored to work under your leadership, and we pray for your good health so that you continue to lead BIAC in the coming years. On behalf of the team, we request our CEO, Mr. Rumee, to present a special memento to our respected chairman, Mr. Mahbubur Rahman. Ladies and gentlemen, we'd like to capture this moment, and we request our chief guest, chairman, BIAC board members, CEO, and today's speakers to stand before the stage for a group photo, please.
Thank you.
শহীদুল ভাই শহীদুল ভাই শহীদুল ভাই ক্লোজ করে দিন
Ladies and gentlemen, I take this opportunity to say a few words about our respected chairman. As you know, he is the current and founding chairman of Bangladesh International Arbitration Centre and the BIAC board. An eminent businessman of the country, he is also the president of International Chamber of Commerce Bangladesh. He is the only arbitrator from Bangladesh for the China International Economic and Trade Arbitration Commission. Mr. Rahman is the chairman of Eastland Insurance Company Limited, chairman and CEO of ETBL Holdings Limited, and chairman of the International Publications Limited, publishers of the Daily Financial Express. He has hosted several international business and economic events in Dhaka, attended by heads of governments, and led many trade and investment delegations to a number of overseas destinations, including leading a few business delegations as entourages of the President and the Prime Minister of Bangladesh. He is the only businessman from Bangladesh to be listed in the 150 high-impact leaders under the Creating Emerging Market Project 2020 at the Harvard Business School, USA. I now request our chairman to make a closing statement.
Bismillahirrahmanirrahim. Honorable Minister, Mr. Anisul Huq, MP, Minister for Law, Justice and Parliamentary Affairs, and the great advocate of the alternative dispute resolution in Bangladesh and supporter of BIAC for all time since he has taken over the office of the Law Minister. Honorable speakers from the legal profession and also in the banking sector, who has been also our supporters for these last 10 years. And I must acknowledge each one of you for kindly joining us today and and today's physical meeting, instead of virtual, the last one we had virtual meeting, and the Honorable Minister has kindly consulted that if we can meet almost after 2 years for this as a physical meeting, and we have organized this. And thank you very much for your kind response. And at this point of time, I must acknowledge, for saving time, I must acknowledge each one of our distinguished speakers who has been supporting us for every time, whenever we need their help and support. And I must say, in this case, in today's seminar, the dispute resolution in the virtual world, the impact of COVID-19 has been a brief one, where we have just been illuminated by the insight of a number of eminent scholars, the great disruption caused by the COVID-19. Sorry for the interruption. And the Bangladesh International Arbitration Centre has just completed its first decade of functioning, but we have little rejoice at this hour with loss of millions of human lives caused by the ongoing pandemic throughout the world. It has disrupted an already overstressed court system in Bangladesh. Its impact on alternative dispute resolution in the country has been all the more disappointing, and BIAC has experienced substantial decline in the volume of its physical hearings. Our training and outreach program also suffered as there was no physical event within the country or abroad. All these resulted in the drastic fall in our revenue earning, as I have mentioned already to you. And now that world has been getting used to the new normal, BIAC is trying hard to facilitate ADR methods, including arbitration through online hearing, alongside physical hearing, or at our premises. Although COVID-19 has frustrated many of its important activities, BIAC hosted a number of webinars since the outbreak of the pandemic, jointly with its partner organizations, including United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, the chief of the Institute from the Seoul, Indian Institute of Arbitration and Mediation, Thailand Arbitration Centre, and London College of Legal Studies on outstanding issues like regional perspective of ancestral ADR instruments on ease of doing business in Asia and the Pacific, ADR landscape in the South Asia region, suggested reforms, confidentiality. Does arbitration need a protocol to regulate the new normal, and why Bangladesh should sign the Singapore Convention on mediation? You may recall that we have signed the New York Convention quite early, I think maybe in 1972 or 73, but for ratification it took quite a long time. This only came in only 2001, if I remember correctly. New York Convention has been ratified in 2001. Despite the fact that we have signed it in early 70s. So, the Bangladesh should sign the Singapore Convention on mediation. These events gave us international exposure, and we had opportunity to highlight our endeavors towards making Bangladesh a regional hub of ADR practices. I am confident that today's seminar and bringing out a special publication on the occasion of the 10th founding anniversary, BIAC will contribute towards unifying world economies and our thrust of integrating best practices of ADR, including virtual norms, at this crucial time of devastation caused by COVID-19. I am immensely grateful to the Government of Bangladesh and more particularly the Ministry of Law, Justice and Parliamentary Affairs for coming forward and making substantial changes in many of our laws wherein provision for ADR have been introduced. These are milestones encouraging parties to resolve their disputes through ADR. Although the legal framework exists, ADR is not yet widely practiced in this modern form. To complement recent changes in the new law, BIAC has been working hard to achieve the goal of improving business-friendly environments in the country. When BIAC started its journey in 2011, the concept of ADR was prevalent just in the books and almost unknown to even the enlightened society of Bangladesh. Through many outreach programs and training courses at home and abroad, BIAC has been successful to acclimatize many organizations and professionals on ADR over the last 10 years of its committed journey towards mitigating sufferings of investors. Over the span of a decade, BIAC has been facing a rise in the demand for its services and the practice of ADR by many commercial organizations and business concerns, as well as financial institutions in the country. I wish this demand continue to increase in the future, and I must also mention that our central bank has already circulated to all commercial banks that they can use the services of the ADR in BIAC. This is indeed a great opportunity on my part to urge upon Honourable Law Minister to continue to support and encourage ADR methods as much as possible throughout the country, especially in resolving commercial disputes, recovery of loan by banks, and the specific performance of contracts between the parties, and using BIAC as a solvent platform for this purpose. I would like to end here with our heartiest gratitude to the Honourable Law Minister for his gracious participation in this session and his kind assurance of supporting the financially, which he has been trying desperately for some time to make the BIAC more practical and making it more stronger to proceed with time. I am confident through your patronization, ADR will find its root in our judicial system, through which our business community as well as BIAC will be jointly benefited in the days to come. I would request the business community and all concerned, including the commercial and financial institutions, to continue to support the efforts and activities of BIAC to place ADR on a firm footing as an effective tool for commercial dispute resolution. Once again, I thank you all for joining and inspiring us and making our 10th founding anniversary celebration a fruitful one. Thank you so very much in this case. Thank you.
Thank you, sir, for your valuable words. Ladies and gentlemen, it has been a privilege to have you with us on a weekend for making today's celebration a complete one. Thank you for your support and cooperation throughout. This marks the end of today's event, and we invite you to a humble lunch at Meghna and Chitra. Our team will assist you. Thank you once again. Allah Hafiz.
চৌধুরী ভাই কোনটা ফিনিশ দিলে হবে